time for Joan Esposito. Live, local, and progressive.
Joan, as always, exceptional work from you from, your TV days all the way up to today. You're truly exceptional, and thanks for this great show you have.
It's time for Joan Esposito on WCPT 820, Chicago's Progressive Talk.
When I get confused about what is going on in the court system, particularly the Supreme Court, and these days that's pretty much how I am 24/7. But one of the people who I like to turn to answer my questions and illuminate me is Professor Stephen Schwinn, who teaches law at the University of Illinois Chicago Law School. Stephen, thank you for returning again.
Joe, it's always my pleasure to be with you. Thank you.
Well, I hope it continues to be your pleasure. I have been under the weather for the last 4 or 5 days and only been able to check what's going on in the world for brief periods of time before I went back to sleep for another 8 hours. But I've been reading stuff that confuses me about what is going on with mail-in balloting. And it's particularly important to me because I signed up, as you can in Illinois, for permanent mail-in balloting. So usually, 4 to 6 weeks before an election, my ballot shows up in the mail. I look it over. If there's something that confuses me, I do some research, and then I fill it out, and I take it directly to my post office and make them hand cancel it, and away we go. But I've been reading, Trump's trying to stop it. It's in the courts, and I'm not sure. The Supreme Court has made a ruling, but it's not a permanent ruling. It's like a ruling for now, and I'm very confused, Stephen. Can you straighten this out?
Joan, I can try, but I got to tell you, this is all very, very confusing. So this actually goes back to March of 2026. In March of 2026, President Trump issued an executive order that purported to regulate mail-in voting in all states across the country. And I just want to emphasize to listeners how important this is. Joan, like many people, you get a regular mail ballot in the mail before elections. Some states do their entire elections by balloting, mail-in balloting. And so this is a really big deal. What President Trump did was 3 things. He first ordered the Department of Homeland Security to compile a list of all eligible voters in every state, and then to convey that list to the states. And I just want to pause for a second on that. That's really weird. The federal government doesn't keep lists of registered voters under federal law and the Constitution. That's the responsibility of the states. And so right out of the gate, we've got some unusual kinds of behavior here. The second thing the order did was to direct the Attorney General to clamp down on certain election-related crimes. Now, that in and of itself doesn't seem alarming, but when we understand the first and what I'm about to describe as the third part of this executive order, it actually is quite alarming. So the third part of the order orders the United States Postal Service to figure out the design of envelopes for mail-in balloting and to require states to comply with that particular design. And then also it requires states to register with the Postal Service all the qualified voters in the state. Then finally what it says is the Postal Service can't deliver any mail-in ballots that don't comport with the design that the Postal Service created and don't cover a person who is on the list that the state submitted to the Postal Service. Now, even as I'm describing that, I hope you and listeners can understand how many possible errors can occur in this system. It's kind of head-spinningly complex, and it is because this isn't the sort of thing the federal government ordinarily does. In fact, it never does this kind of thing. Elections are left to the states, not the federal government. So that's the kind of backstory. Now, a couple of cases emerged in federal court. The federal court initially ruled that the executive order was illegal, unconstitutional, and that the president exceeded his authority in issuing it. The government took the case up to the Supreme Court and said, we're not going to make an argument about the underlying merits of the executive order. But we are going to argue that the states who sued, and Illinois was one of these states, that the states who sued lack standing and that the case isn't ripe. And what that means is that the states were unable to demonstrate that they would suffer the kind of harm that would allow them to sue in federal court because the Postal Service hadn't yet implemented its regulatory scheme and DHS hadn't yet compiled its list. Basically, the states filed too soon. And on Monday, the Supreme Court agreed and allowed the Postal Service and Department of Homeland Security to go ahead. Now, most recently, just this afternoon, the states refiled a new case, lodging a new challenge based on regulations that the United States Postal Service actually has now promulgated. And I think they've got a much better case at this point for standing and ripeness, and we'll kind of see where it goes from here.
Correct me if I'm wrong, but isn't voting supposed to be the purview of the states? I know that, the Postal Service, I guess, is federal. So if you're going to mess with voting, I guess you'd have to use an avenue like that. But this seems like it's messing with voting. And it seems like the states could just go to the court and say, hey, they're messing with voting. And that's this is the Supreme Court wants everything to be about states' rights, states' rights. No, there's no Roe v. Wade. It's all up to the states. Shouldn't this be the same thing? Whoa, no, it's all up to the states.
Joan, you're exactly right. And that's what the Constitution provides in the Elections Clause, the Electors Clause, and the fundamental right to vote, that states have the primary responsibility for regulating the vote. And under two federal laws, the National Voter Registration Act and the Help America Vote Act, states are actually charged with keeping and maintaining their voter lists, not the federal government, the states. Now, the Elections Clause in the Constitution does say that if Congress wants to enact a law to regulate the times, places, and manner of federal elections, that Congress can do that. The emphasis here is on Congress can do that. The president has no unilateral authority whatsoever to do this, and that's exactly what the states were arguing. Now, my own view is that they've got a really good case on the merits. The problem is that the government hasn't defended this on the merits yet. It's simply said that the states lack standing and that their case isn't ripe, and they've succeeded on that ground alone. If and when the courts do come to the merits of the case, basically the argument that you outlined, I think the courts are much more likely to rule in favor of the plaintiffs and to say that this executive order is illegal.
Does it? Oh, yeah, shoot, we've got a break. When we come back, I want to ask you about this whole idea of standing. Are they being picky? Should the states have known that if it hasn't been put into effect, they can't oppose it? Or were they? I don't know. It seems like we're really in the weeds here looking at the fine print. Professor Schwinn and I will be back to try to make a little more sense out of this right after this.
Now back to Joan Esposito, live, local, and progressive on WCPT 820.
Professor of Law Stephen Schwinn, he's at the University of Illinois at Chicago, is trying to explain to me this recent Supreme Court ruling on the Trump administration effort to mess around with mail-in balloting. And if I understood you correctly, part of the reason why the Trump administration has been successful so far is because their argument was, the states with their lawsuit, they jumped the gun. They filed a lawsuit against something that officially hadn't even really begun yet, and that can't be fair. And the Supreme Court agreed with them. Is that unusual? Because, is it unusual to file a challenge to something that is just being moved through the gears and hasn't officially begun? It seems like we're getting really picky here.
Oh, Joan, we are getting super picky here. No, this isn't unusual at all. Organizations, states, people will file what we call a pre-enforcement challenge on a regular basis. And this wasn't even a pre-enforcement challenge. The states are faced with an imminent, impending midterm election. They've got to start to mail out these mail-in ballots that you'll receive within a matter of weeks. And so they really are in a pinch here. The Trump administration effectively gamed the system in the way that it set up this litigation. And I'm going to try to describe this as clearly as I can. So the Trump administration, pretty late in the game, came to the idea that it was going to implement these regulations to go ahead and enforce the executive order. Now, as soon as it started to move to do that, the states sued. And they said, well, look, if the Trump administration is actually going to do this, we need to start ramping up things very, very quickly because we have an election coming up in the fall. And moreover, based on the way this thing is designed, it sounds like there are going to be a lot of mistakes, and the states are going to need to be prepared to deal with those mistakes. And so the state said, we've actually been sufficiently harmed. What the Supreme Court said was, you haven't been harmed in the way that you need to be harmed to get into federal court because we still don't understand exactly how the Trump administration is going to implement and enforce this executive order. And moreover, and Joan, you're going to love this, moreover, the Trump administration in the executive order wrote that the DHS and USPS should only comply with it insofar as it complies with existing law. And the Supreme Court read that language and said, well, look, the administration itself is saying that it's binding itself to actual law, and so therefore we don't expect it to act illegally, and therefore we don't expect it to harm the states in the way that they're saying. Just kind of crazy town reasoning, in my view. And so that's a problem on the front end, but it gets even more complicated and more in the weeds on the back end. So the problem that the Supreme Court and the Trump administration has set up for the states is that they can't sue to stop this kind of thing too early, because if they do, they won't be able to demonstrate the kind of harm that they need to get into federal court for the reasons that we've talked about. But on the other hand, they can't sue too late. And here's why. The Supreme Court, in a different line of cases, developed a principle, a kind of doctrine that we call the Purcell principle after a Supreme Court case called Purcell. What this principle says is that federal courts shouldn't change state election rules too close to an election, even if those rules violate the Constitution, because that'll create voter confusion. And so we're now on top of this election. And so can the states sue now, or are we too close to the election to change this rule that President Trump put into play? And so between the standing and ripeness pieces on the front end and the Purcell principle on the back end, the states have a narrow window when to sue. And they don't really even know when this window occurs because the Supreme Court hasn't really specified it. So again, they filed another lawsuit this afternoon now looking at the new USPS regulations, and I think they're in a much better position to demonstrate that they're going to be harmed by this new regulation that actually is going into place and will allow the courts very quickly, I hope, to get to the merits of this. But, Joan, I mean, you mentioned it, and you're exactly right. All of this is creating confusion. Many commentators, myself included, think that that's the point.
People confused, and then they won't know what to do. And if they always vote by mail and aren't set up like me to get it automatically, they have to actually make an effort to it. Maybe they just won't. I understand that. And let me back up a second, because you said one of the things the Supreme Court pointed to was that the government said, well, this is what we want to do, but we'll basically only do it within the confines of what is legal. And okay, if you're going to just follow the law, then why try to change this, the way people mail in ballot anyway? If you're going to follow the law already exists, so just go home.
Joan, I love talking to you. You cut right to the chase. That is exactly right. You put your finger exactly on it. If they're going to comply with the law anyway, just comply with the law. You don't need a new executive order to do it. Now, the Supreme Court has been using this kind of language as a sort of get-out-of-jail-free card for the Trump administration. And the Trump administration has learned from Supreme Court rulings that if it includes in an executive order language that says we're only going to enforce this so long as it's consistent with existing law, the administration knows that that's basically a way to get around any court holding it up from doing what it wants to do.
I understand the idea of doing what you need to do to get your idea put into place, but it feels icky when somebody is like twisting the law and looking for the right wording to create a loophole. It doesn't feel like the law is supposed to be straightforward, and it's supposed to be honest, and it's, supposed to be clear. And this feels like a backroom deal kind of way to get what you want. Not that that's going to affect anybody, and not that they care, but it's just repugnant to me.
It is, and this is a point that Justice Jackson made in a dissent that she wrote for herself in the case on Monday. It's really worth reading, and I would urge readers to take a look if you get an opportunity. She calls the court out on this, and she says, look, the Trump administration is basically playing the courts, and the Supreme Court is in on the game. And we just can't do that. We can't be in that business. The Trump administration shouldn't be doing this. It raises all kinds of red flags for the courts, and we really should be calling them to the carpet on this kind of tactic.
But they're not.
But they're not.
Some people who have been writing recently have been writing things about John Roberts that, because initially it seemed like maybe he would be the person to bridge the liberal and the conservative, but it's turned out that he's just as conservative as the rest of them. And I've been reading, articles that are like, why are you surprised about John Roberts? This is always who he's been. This is always what he has wanted to accomplish. So, don't say you're disappointed in him, because he's doing what we all knew he would do. How do you feel about that?
I think that's spot on. I mean, this is somebody who has a public record going all the way back to the 80s that demonstrates exactly what he's wanted to do and what his agenda is as a justice and chief justice of the Supreme Court. And we really shouldn't be surprised by anything that he does. I think, the folks who say that John Roberts is an institutionalist and that he's part of a kind of middle wing on the court that's not quite as conservative as others on the court, I think what they're looking to is the far right wing of the court, where you do really have some unusually conservative justices in the form of Justice Alito and Thomas, for example. And by comparison, Justice Roberts is more moderate. That's true, but still very, very conservative.
More moderate than the most extreme human beings on the face of the earth is not a compliment.
No, it's not a place I'd want to find myself,
No.
But I think that's where he is. Yeah.
Yeah. It's just what's going on with the court right now is very, very frustrating. And again, when I first was doing this show years ago, and I would talk to people about the idea of expanding the Supreme Court, and virtually every Supreme Court expert I talked to was like, no, you don't want to do that, and here's why, and blah, blah, blah. In the last couple of years, those conversations have changed when I've talked to people, particularly lawyers who become journalists and report on the Supreme Court. And more I'm hearing the only way in our lifetime to see different rulings is to expand the court. Yes, reform is necessary, and that's great. But the assumption seems to be that any reforms passed will not affect the current Supreme Court. They'll be grandfathered in. So if you really, really want to see a Supreme Court that more accurately reflects the people of this country, you have no choice but to expand the court. What are your thoughts on that?
I don't disagree that we ought to be looking seriously at court expansion or court reform or both. I want to remind listeners that there are other ways that Congress can affect what's going on at the Supreme Court. Congress has tremendous power over the court. It funds the court. It can set the Supreme Court's appellate jurisdiction. It can even, if it wants to, tell the court that it can't hear cases. This is pretty expansive power that Congress has. And if Congress has the political will to exercise it, it really could effect deep and lasting change at the Supreme Court. The problem here really is one of political will. We haven't seen a Congress that's willing to take these measures, and I'm not sure that we will anytime soon.
Okay, but if Congress passes these laws, this court reform, and conservatives find some way to have standing to appeal it, and it works its way to the Supreme Court, I mean, come on. They're going to take a look at this and they're going to say, oh, yeah, well, you know, it's a good idea, but they didn't put the periods in the right place in the sentences. Therefore, we're going to overturn this law. I mean, how do you rein in a court that seems to have the final word on any law passed?
Well, I'll tell you what I do. And if there are any legislators listening, I'd be happy to advise on this. I'd write a law that reforms the court and then specifically divests the Supreme Court of appellate jurisdiction over a ruling on that law, which Congress can do. And that would mean that the law would go into effect, and that Congress could divest not only the Supreme Court, but the lower courts of jurisdiction to hear challenges to the law. And we'd have no judicial oversight on that law.
Well, any legislators that are out there listening, please, please, please. I talk to a lot of Congress people on a fairly regular basis. I'm going to tell them they need to talk to you. I really, seriously, because this can't go on. Any good that we try to do, I mean, Joe Biden tries to get rid of student debt, and somehow that's not acceptable. That's a bad executive order, but all of Trump's executive orders are good. Come on. It doesn't make any sense. Anyway, I have chatted with you far too long. We have gone past our time, which usually happens when I talk to you, Stephen. But thank you for being here. Professor Stephen Schwinn from the University of Illinois, Chicago School of Law. Thanks again.
Joan, always a great pleasure. Thank you.